Yes.
My Lord, we have looked at the replying affidavit, and it insists that the respondents...
Let's start here.
Yeah.
Why are we here?
We are here because we asked for the production. Actually, thank you, my Lord, for returning me to the course. We are here on a habeas corpus application, and you did order that the body be produced, that the second petitioner be produced today by the respondents. He is not in court. He has not been produced. And looking at the replying affidavit of the respondents, they are insisting that they do not have him. Through Corporal Samuel Kitegi.
Senior Counsel.
Yeah.
Today we are here to confirm whether there is compliance with the directions of the court.
Indeed.
So that's where we start.
Okay, I give way to the court.
So,
I yield.
Mr. Maro.
Your Lordship, on behalf of the first to the sixth respondent, I appeared before you yesterday, Your Lordship, and in line, rather in compliance with your directions, pursuant to this order dated the 30th June 2025, I confirm, Your Lordship, that indeed I complied with your direction, order number 1 and 2. I did file a replying affidavit. The same is dated 30th June 2025. To that extent, Your Lordship, sworn on 30th June 2025.
Understand?
And served, filed, Your Lordship, I believe it is in the court file. So to that extent, Your Lordship, I want to believe that your order of 30th June 2025 has been partially complied, Your Lordship. What you have not been able to comply, Your Lordship, with is part of order 5, which directed that my client will produce the second petitioner in court today. Your Lordship, in our affidavit dated 30th June 2025, we have given an account of the action taken by the respondents, Your Lordship, in particular, the second respondent. The affidavit is shown on oath, Your Lordship.
So in the affidavit you have done what?
You have been able to give an account of what happened that resulted into the application that is now before you. And Your Lordship, at paragraph 20, my client, Your Lordship, have confirmed that they did not arrest the second petitioner. And so, Your Lordship, the second petitioner is not in the hands of my client, neither is in their custody. It is in the interests of both the petitioners and my clients that the whereabouts of the second petitioner be established, and the investigation is ongoing. Your Lordship, with the permission from me, I have looked at the further affidavit, and at paragraph 8 of that particular affidavit, the CEO of our society, Law Society of Kenya, has indeed confirmed without troubling evidence that the second petitioner was picked by the respondent. Your Lordship, the nature of this application is that, Your Lordship,
So which affidavit have you looked at?
there is an affidavit that has been served this morning.
Give it a name.
It is a supplementary affidavit sold by Florence Muturi, dated today. Paragraph 8, Your Lordship. The one Florence Muturi indicates that the second petitioner was picked by my client, Your Lordship. There is no evidence that have been produced in this court, Your Lordship, that indeed the second petition was picked by my client. Your Lordship, the nature of this application is that he who alleges must prove. Section 107 of the Evidence Act, Your Lordship, demands that counsels appearing for the first and second petitioner do convince this court that indeed they saw, or rather they witnessed, and confirmed that my clients, in particular the second respondent, did pick the petitioner. Short of that, Your Lordship, this court, I beseech, should give my clients an opportunity to conclude the investigation so that the second petitioner, Your Lordship, can actually be arrested, because we want to believe a complaint was made. And when my clients visited the apartment.
Is that on oath or you are speaking from the back?
Your Lordship, that is in my affidavit.
Which paragraph?
This is a paragraph. Your Lordship, this is at paragraph. Paragraph 4 of the affidavit, Your Lordship. There is an OB
Where are those affidavits?
that was registered.
Yes, relax.
cannot find it. Do attend constitutional conference. We can't have that many mistakes.
Yes.
Your Lordship, I was at paragraph 4 of our affidavit, where we confirmed that the second petitioner was under investigation for his involvement in the just concluded demonstration, Your Lordship. Your Lordship, if you look at paragraph 14, it clearly indicated that as at the time my clients visited the apartment of one Ndiangui, Kinyagia, the gentleman was not at his apartment. He had left. The caretaker has also confirmed that the gentleman left in the company of two other unknown ladies, Your Lordship. Their identities
Where
was
do you
not
get
disclosed.
that?
This is at paragraph 14 of my affidavit, Your Lordship.
That is the deponent stating.
Yes,
It's not the caretaker.
yes, Your Lordship. The caretaker, I'm aware, Your Lordship, the caretaker is not present.
No, it's not the caretaker stating. It is the deponent.
Yes, Your Lordship,
So-
but part of this
So
information.
that I record you,
Yes.
retain information as it is, rather than attributing it that it is the caretaker speaking, because the caretaker has no affidavit here.
Yes, Your Lordship. This
So it is the
statement of,
deponent
someone
stating
intake. Yes.
that information is from the caretaker.
Your Lordship, if part of it, because when my client
I've read that bit.
yes, because when my client visited, they did not find the petitioner, the second petition. So this information they retrieved it from the caretaker, Your Lordship.
Yes.
That's why it is.
So that is according to the deponent.
Yes, Your
That's what the caretaker said.
Yes, that's the position.
It's not the caretaker saying.
Yes.
Okay.
So, Your Lordship, this necessitated my clients to break into that particular apartment. And Your Lordship, an inventory
So who
of
broke in?
my client that is the second respondent.
Oh, they were present.
Yes, they were present.
The officers.
Yes,
IG was present.
the DCI. Yes, Your Lordship. That is the second respondent.
You said your clients.
Yes, Your Lordship.
I'm
I am
taking
here
it.
for the first to the sixth respondent.
Correct. So
Yes.
I'm trying to get the names of those who are present. Because you said your clients were present.
Yes.
So who are these?
Your Lordship, somebody said he was present, who the one was on this affidavit, Your Lordship, among others that have not been identified.
Remember,
Yes,
we are in court
yes,
with specific people
yes.
who are named.
To that extent,
Those are the people you
Your Lordship,
represent.
can we retain it that the second
You
respondent?
know, I should be recording you and not misrecording you. You understand? So when you say your clients were there, number one is IG, number two is DCI. So they were present.
Yes. Then, as such,
Yes.
And Your Lordship-
Just a minute. IG, DCI. Who else?
the officers, Your
The
Lordship,
CS.
Your Lordship, so that we are clear, Your Lordship, these are the officers for the first and second respondents who were present, Your Lordship. Put it as Your Lordship, it's being recorded. The Inspector General of Police in person did not visit, but the officers did visit.
No,
Yes.
it depends on how you want us to record you. So if you say your clients were present, these are your clients.
Yes, and I have narrowed down, Your Lordship, to the second respondent.
So the DCI was present.
Yes, officers of the second respondents. In particular, one is indicated here as Samuel K. Your Lordship, when they broke in, an inventory has already been taken, was taken, Your Lordship, and it is annexed to number 1 of my affidavit, and all the items that were collected have also been itemized there. Your Lordship, the second petition so that he can answer to some of the concerns that the second respondent raised, Your Lordship. The second petition, Your Lordship, I wish to confirm before this honorable court that is not either of the respondents. It is now very difficult, Your Lordship, for order number 3 to be complied with. Order number 5, Your Lordship, directing that the second petition be produced in court, Your Lordship, because my clients, Your Lordship, I insist, do not have the
Do
second
not insist in court. You persuade the court.
Your Lordship, I persuade this court.
So if you are insisting, they will insist. And
Your Lordship,
then
there are many. I am just expecting another from them.
let me conclude.
Yes, Your Lordship.
If you take that route, they will insist that the next thing you will have an exchange. So in court, we don't insist, we try to persuade.
Your Lordship, I stand guided and I want to believe, Your Lordship, I have persuaded this honorable court because we are all here to seek justice and for the
So what do you want us to do, as you say you do not have him?
Your Lordship, according to the affidavit that I filed yesterday, the investigations are still ongoing. We are still pursuing the petition. We can be given more time for us to actually investigate.
Are you looking for him or you are pursuing him?
We are
Those are two different things.
Your Lordship, as I indicated, if you look at paragraph 4, a complaint was also made.
Mr. Marwa, the deponent is speaking. Now you are in court presenting.
Yes, my client.
So if you want to use his words, it will make a difference. So what are you asking the court to do for now?
The court should give us more time, Your Lordship.
So are you looking for him or you are pursuing him? You know the difference.
Your Lordship, we are looking for the petition. Your Lordship, that is all, Your Lordship. I request that at this point, Your Lordship, my clients to give them a bit of time.
Enough with the lies. Your clients are the abductors. Go tell them to produce the second petitioner in court. Enough with the lies. You must stop the abductions. You must stop extrajudicial killings. We will not come here to listen to your stories. You have abducted someone. His family is crying, and you are here telling us stories. Enough is enough. Extrajudicial killings and disappearances must end now. We must stop this madness. We must stop these evil things you are doing to us. It is not right to abduct someone and not present them to court. And you are here telling us stories about... Let me speak. I will sit down. This is not right. Why should they abduct someone and instead of producing them to court, they come here to start telling us stories about, I don't know, my client did this. Your client what? Then what are we supposed to do? If the people who are supposed to protect us have turned out to be the greatest threat to our security.
Can we proceed, Senior Counsel?
Yes. Well, we have heard the counsel for the respondents. I want to begin by referring you to the wording of order number 5. And if you allow me, I'll read it in extenso. That the Inspector General of Police and the Director of Criminal Investigations were named as the first and second respondents, and also the fifth and sixth respondents in their personal capacities, are hereby directed to produce Ndiangui Kinyagia, the second petitioner in court tomorrow, the 1st of July 2025. In default, the Inspector General of Police and the Director General of Criminal Investigations do attend court to show cause why Ndiangui Kinyagia, the second petitioner, should not be produced in court or released. It is clear, my Lord, that in the absence of Ndiangui Kinyagia being produced in court, the Inspector General of the Police, the first respondent, and the Director of Criminal Investigations, the second respondent, ought to be here before you. Nothing whatsoever has been said about their blatant disobedience. There's nothing in the replying affidavit of the respondents of Samuel Itegi to tell us how far they have gone with the investigations, and what they have done in Kinyagia. This matter has been very, very public. That yesterday, my lord, the DCI, the second respondent, at 4 p.m., long after you had adjourned the hearing and given your orders, therefore we assume that he knew he's supposed to be in court today, decided to appear before the public and deny having Ndiangui Kinyagia in his custody. So he will deny publicly, but he will not come to assist the court to reach a decision. And he will deny publicly in a matter that is sub judice. A very, very disturbing feature of the affidavit of the respondents is to be found in their annexure, their sole annexure to their replying affidavit, which is the inventory of the things taken from Ndiangui Kinyagia's side. Is page 10 and 11. If you look at that, my lord, and look at our annexure attached to the affidavit, further affidavit of Florence Muturi, sworn on the 27th day, yesterday, not yesterday, 27th day of June, which was Monday, where we attached as FM1 the inventory taken of items taken from Ndiangui's house. You will, on the face of it, discover that the annexure SI1 of the replying affidavit of the respondents appears to be a forgery. And which makes the second respondent.
Which one are you referring to?
I would request that my lord has both of them. The one attached to the respondent's replying affidavit, the first page, and the one attached to our further affidavit, for FM1. Ours is in color. Theirs is in black and oh, I'm told it's also in black and white. It's my copy that is in color. If you look at those two, my lord.
Just give me a minute.
Also, here, house. This one does not have recovered. Yeah. (2025) on the petitioner's supporting affidavit is typed, while the 25.
I thought you go over the respondents.
Okay, let me do that.
And when you are done, you now come to the petitioner so that there is.
It's methodical.
Yes.
Okay.
So
the differences we have noticed several
the date
differences.
has 21st.
I had
June
ST
20, yes.
to signify 21st.
Yes.
And the date 2025, 20 is typed,
Yes.
25
Yes.
is written by hand.
Yes.
Then it has 6 items. It ends at number 6. Jane Jango. Then when you come to the respondents, not to the respondents, to the applicant.
So you're done with the respondents?
I'm done with the respondents.
So the differences are?
The differences are
date,
the year, 21st does not have an ST.
Items are 6. I'm done. I've marked 21st ST.
Yes, and then the 2025 is typed fully. It's not written by hand. Unlike theirs.
I'm on the respondents.
Oh, we finished with the respondents. I've now started with ours.
So I'm confirming that I got you right.
Yeah, the differences
21st
ST and 25 written in pen.
Yes.
Instead of typing.
Okay. Then the items are 6.
Are 6.
The witness, Jane
Jango.
Mm-hmm.
Yes.
Okay.
Those are the 3 notable things in that one.
Mm-hmm.
On the one by the petitioner,
yes,
the date does not have ST. And I've just noticed one more issue, but I'll mention it. Doesn't have ST, and 2025 is wholly typed, not written by hand. And this particular, if you allow me to point a difference I didn't point on the other.
No, let's go.
All of it, yeah.
No, let's go the way you went.
Okay,
the
and then
items
I
you
come
identified. Then you now highlight the one you think is outstanding.
Inventory of items above the date taken.
Mm-hmm.
Inventory of items taken.
Mm-hmm.
It says ceased from inventory of items taken.
Stroke ceased
for the purpose of investigations.
Yes.
Note that one. I'll come back to show a difference somewhere else. Then we go to the items. My lord, this one has 7 items. That is the petitioners. And there is overwriting on the item numbers. Number 6 is cancelled because number 5 appears to continue up to number 6, so it's cancelled. Number 6 is cancelled. Number 7
item,
the numbering. You can see a cancellation on the letter 6 and then an imposed writing on the number below to be 6. A cancellation below number 6, the imposed number 6, and then an imposed number 7. So the petitioners have 7 items and the numbering has been changed.
Yes.
Then witness, it is cut, but it appears, the signature appears to be there. Other one. Where is it? can see House of Kinyagia, Ndiangui. A feature that is also will distinguish the petitioners is the item number 7, which talks of okay. Item number 7 is that on our annexure, the petitioner's annexure,
Your Lordship, I don't know if it is proper at this moment for me to clarify.
No.
is 2 pages. Ours, it's all on 1 page. Oh, this is yeah. So we do not have the signature of ours. This is sealed. This is sealed. No, this is sealed. No. No, that's sealed. The last distinction between the two I would like to point out now is on the rest. It is inventory of items taken stroke seized from the suspect, seen for the purpose of investigation. Now, if you look at
So
petition,
the words inventory appear at the top.
the word that is not similar in both is the word sin, as in sin of crime. Whereas the respondents, 1, in that heading, has the word sin, and these are the word sin does not appear on the copy of the petitioners. I'm not a document examiner, but even the writings appear different. So with respect, we suspect that the exhibits annexed the Director of Investigations matter said by the caretaker, who has not sworn an affidavit, and who appears to have made a general statement, not a statement to the deponent. If you look at paragraph 14 of the respondent's affidavit, it says, the said caretaker informed officers that the second petitioner had left the house earlier in company of another man and 2 unknown ladies. He doesn't say he has been told by her, which he verily believes to be true. It's a marketplace statement. He said to the officers, this is hearsay, should be expunged, unless if the lady herself swears affidavit and avails herself for cross-examination. What if the 2 others he left with were an advance party to abduct, while the others come back and search? Those are things we can never know.
Yes.
I sit just down with one proposition. The coincidence of the house being broken into by the police, which they now admit, and my colleagues will be dealing with the illegalities of that, and his disappearance, and the conduct of the DCI and the police generally in this country in matters relating to abduction, leads to the inescapable conclusion that indeed they arrested him and then ransacked his house. I yield to my colleagues.
My Lord, very briefly.
Just a minute.
Start from the point that I assume that the respondents recognize that we are in a country operating under the rule of law. And if they accept that fact, then a competent court having made an order, I've never seen orders that are so express and explicit like this one, directing the IG, Mr. Kanja, and the DCI, Mr. Amin, to produce Mr. Ndiangui Kinyagia on the 1st of July 2025 at 11 a.m. That's the first part of that order. It is 12:43 at the time I'm speaking. And the 2 gentlemen have not produced Mr. Ndiangui Kinyagia. This court specifically directed them that if they fail to produce him, in default, they have to attend court to show cause. So we all agree there is no production, but I can see they are not here. I'm only seeing Mr. Maro. He's not the DCI, he's not the IG. So if you're operating under the rule of law, at the very bare minimum, the 2 gentlemen should be in court doing the explanations which counsel is purporting to do from the back. Because underlying all this is the liberty and the life of a citizen at stake. We may speak all the English, but there is an individual whose life and liberty is at stake at the end of the day. And that should be the primary concern of all the parties and the law. And in furtherance to that limb, my lord, Mr. Ndiangui seemed to have only attracted the attention of the respondents.
That is the second petition.
The second petition seemed to have only attracted the attention of the respondents on the 18th of June.
On 18th.
18th of June 2025, and that is, my lord, as per the Annex 10, the replying affidavit, page 10. Sorry, on the 19th of June. 19th of June, as per the annexure found at page 10 of the replying affidavit, is a letter signed by one Zachary Kariuki, the DCI operation support unit. And that letter, my lord, it is the first time that the question of liberty of the second petitioner is being discussed. Before that day,
Just a minute. You are referring to
page 10 of the replying affidavit of the respondents.
that item is
It's a letter dated 20th of June. It's a letter from National Police Service, the letterhead, Directorate of Criminal
so
Investigation.
it's addressed to who?
It's addressed to the Director General Communications Authority of Kenya. The DCI is addressing the Director General Communications Authority of Kenya to help them trace.
The letter is dated?
Dated 20th of June 2025. And on the 21st of June, they are its residents, as confirmed by the inventory, the two inventories. So the only person who publicly is known to be interested in the second petitioner are the respondents, no other person. And it is also not in doubt that he disappears on that 21st of June. If it quacks like a duck, if it walks like a duck, it can only be a duck. And in their replying affidavit, they are speaking to recoveries of items in his house, confirming presence in the scene. They are not speaking to investigating or finding this man. If they were really minded to protect the fundamental rights of the second petitioner, and if they didn't know where he is, the report to court today will have been the number of witnesses they've questioned, the track and trace they have deployed, the CCTVs they have seen around the scene, to explain the whereabouts of a Kenyan who they will have said they took in their custody. But to the extent they are not talking about that, they are only talking about the items they've recovered and a purported expose. We can only conclude they have it. And those are the questions. If the orders of this court issued yesterday were complied with, we will be asking the two gentlemen and their subordinates whose names appear on the inventory to have been present at the residence of the second petitioner.
Yes.
So, my Lord, as I conclude, I will pray that this honorable court, to the extent that we have this order still in force, to give dignity and to assert the authority of the judicial process, with the participation and the presence of the two, Mr. Kanja and Mr. Amin, in person answering this question, and their subordinates who have signed this inventory. Only one agency in this country the supporting affidavit of Florence Muturi have not been denied the presence of Subarus and the gentlemen in those Subarus in civilian in violation of the law as noted. They make no mention to them. We do give justice to the second petitioner and his family.
You want to add?
Yes, Your Lordship.
There
are certain aspects, Your Lordship. I'll be
Which
speaking
ones?
directly to the affidavit.
Which ones?
Yes, Your Lordship.
Which ones?
Your Lordship, I'll be sticking to the contents of our supplementary affidavit, the issue of the arrest warrants, and averments by manual for the respondents in terms of their interest with the second respondent.
But what has senior counsel done? What has Mr. Willis Otieno done?
Your Lordship, if you would indulge me, perhaps you would find that.
I will, but I want to find out
yes, Your Lordship.
what you are adding.
Yes, Your Lordship. I'd be speaking to the fact of, Your Lordship, there was an averment by counsel to the respondent that they are looking for the second petitioner and not investigating. I would wish to point out to this honorable
But that's what he
specific
said.
paragraphs.
But that's what he said.
Yes, Your Lordship. I'll be alluding to their replying affidavit where they indicate that he is a person of interest, as well
Yeah,
as
they have said that.
Your Lordship, the averment was that they are looking for it. Your Lordship, there's a difference between a missing person, Your Lordship, and a person being investigated for having committed a crime. That was the distinction.
You know, we really have to try and focus on why we are here. You understand the council?
Yes, Your Lordship. Yes.
Today was meant to be a very brief day. So just let me know what you want to add. We have read this affidavit, haven't we?
Yes, Your Lordship.
We have read the inventories, haven't we?
Yes, Your Lordship.
Yes. So just add what you want to add instead of making a day very long. Give us your name.
I'm Mr. Abner Mango, Your Lordship.
Mr.
Abner Mango.
So I can have Mr. Mango.
Yes, Mango is fine.
It's easier. So proceed, Mr. Mango.
Yes, Your Lordship, I'll be very direct and speak to what has not been. Your Lordship, just referring the court to the affidavit in support of the agency. Your Lordship, there is a miscellaneous.
Let's not go there. We read that affidavit. We are here. We are part of that agency.
It has not been spoken to. It has not been spoken to, Your Lordship. There is the second annexed, the inventory was the first one, but the second annexed, Your Lordship, to the affidavit in support of the agency, is a miscellaneous application, number E2362 of 2025. This is the affidavit dated 27th of June 2025.
So which affidavit are you looking at?
There is an affidavit in support of agency. Your Lordship, just to give you a brief background.
I have to be there before you
Yes.
give me a brief background.
I'm taking you to 27.
So I'm looking for that document.
Very well.
Don't be in a hurry. You must be looking at a different document.
Yes, Your Lordship.
Which document are you looking at?
Your Lordship,
Give me the
there's a
title of that document.
Yes, there's a certificate of agency filed on 27th of June, and there was a further affidavit in support of the certificate of agency.
When here we go by the date, the document
Dated
is dated.
27th of June 2025.
When is this agency dated?
27th of June 2025.
Certificate.
Yes, Your Lordship. And that is why I was giving you the background that the initial certificate was filed on 24th, and having not been given any directions, another certificate of agency was filed on the 27th of June.
And when was the application seen?
On the 27th of June 2025 is when Your Honorable Lordship gave direction. After the subsequent filing of the second certificate.
24th was which date?
24th was on Tuesday.
It was filed at what time?
24th at 9:34 a.m.
And we sit up to when?
You see? And Your Lordship, that's what prompted it.
No.
Yes.
See, you seem to be saying
Yes.
we were late in acting on your application.
Yes. Yes.
So we sit up to what time?
5 p.m.
Do you know when we saw this?
on 27th.
And you know it has to be allocated.
Yes.
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 So you know when it was allocated.
On 27th. That was after the subsequent certificate.
It can be dated 24th but filed on 26th.
No. Filed on 24th.
I can easily confirm here.
Yes, Your Lordship.
No,
We
but
can confirm.
just check. When was
In
it
fact,
filed?
the first ground of that certificate was that we had filed on 24th. That was our first.
Who filed?
Through the firm of VRA.
It was not you. Sindio?
Yes, Your Lordship.
Yeah. So you are told we file. He gave an assistant to upload. Maybe the system was down. That week we had the system was down. Yeah. So you are banning.
Your Lordship, your attention.
Wait. Robert, are you able to see at what time did they upload?
27 at 12:14, 30.
And he's saying they uploaded when? That is a certificate of agency.
Yes,
The initial petition.
on 24th of June 2025 at 8:19 p.m.
You see? So who sits at night? Don't come here and make an allegation in front of the media. You accuse us as if we don't work. So that was
Your Lordship, my
24th.
apologies.
Wait, this is just same umefanya mbaya, only that you didn't know. So that is 24th. Then you come here and that was which day of the week? No, not 24th.
Was Tuesday.
It's on Tuesday. And then you sit from morning 8:30 up to some time before you
typed. While the 25,
I thought you go
yeah,
over the respondents,
okay, let me do that.
and when you are done, you now come to the petitioner
that.
so that there
It's
is,
methodical.
yes.
Okay,
So
the differences, we have noticed
the
several
date has
differences.
21st,
I had
June
ST
20,
to
yes.
signify 21st,
yes,
and the date 2025, 20 is typed,
Yes.
25
yes,
is written by hand.
yes.
Then it has 6 items. It ends at number 6. Jane Jango. Then when you come to the respondents, not to the respondents, to the applicant.
So
the
you're
petitioner.
done with the respondents?
I'm done with the respondents.
So the differences are
the differences are
date,
date
the year,
21st does not have an ST. And the
items
year,
are 6. I'm done.
and,
I've marked 21st ST.
yes, and then the 2025 is typed wholly. It's not written by hand. Unlike theirs.
I'm on the respondents.
Oh, we finished with the respondents. I've now started
Yes,
with ours.
so I'm confirming that I got you right.
Yeah, the differences are
21st.
ST and 25 written in pen
Yes.
instead of typing.
Okay. Then the items are 6.
Are 6.
The witness, Jane
Jane
Jango.
Jango.
Mhm.
Yes.
Okay.
Those are the 3 notable things in that one.
Mhm.
On the one by the petitioner,
Yes.
the date does not have ST. And I've just noticed one more issue, but I'll mention it. Doesn't have ST, and 2025 is wholly typed, not written by hand. And this particular, if you allow me to point a difference I didn't point on the other,
No, let's go.
all of it, yeah.
No, let's go the way you went.
Okay,
The
and then
items
I
you
come back.
identified. Then you now
Come back.
highlight the one you think
Okay.
is outstanding.
Inventory of items above the date taken.
Mhm.
Inventory of items taken.
Mhm.
It says ceased from inventory of items taken.
Stroke ceased.
For the purpose of investigations.
Yes.
Note that one. I'll come back to show a difference somewhere else. Then we go to the items. My lord, this one has 7 items. That is the petitioners. And there is overwriting on the item numbers. Number 6 is cancelled because number 5 appears to continue up to number 6, so it's cancelled. Number 6 is cancelled. Number 7,
Item.
the numbering. You can see a cancellation on the letter 6 and then an imposed writing on the number below to be 6. A cancellation below number 6, the imposed number 6, and then an imposed number 7. So the petitioner has 7 items and the numbering has been changed.
Yes.
Then witness, it is cut, but it appears, the signature appears to be there. Other one. Where is it? You can see House of Kinyagia, Ndiangui. A feature that is also will distinguish the petitioners is the item number 7, which talks of okay. Item number 7 is that on our annexure, the petitioner's annexure,
Your Lordship, I don't know if it is proper at this moment for me to clarify.
No.
is 2 pages. Ours, it's all on 1 page. Oh, this is yeah. So we do not have the signature warrants. And this is sealed. This is sealed. No, this is sealed. No. No, that's sealed. The last distinction between the two I would like to point out now is on the rest. It is inventory of items taken stroke seized from the suspect, seen for the purpose of investigation. Now, if you look at
So
petition,
the words inventory appear at the top.
The word that is not similar in both is the word sin, as in sin of crime. Whereas the respondents one in that heading has the word sin, and these are the word sin does not appear on the copy of the petitioners. I'm not a document examiner, but even the writings appear different. So with respect, we suspect that the exhibits annexed there's nothing in the replying affidavit of
And Your Lordship, it can't be found even before the lapse of 7 days.
He has been missing since
I believe
21st. So today is 10 days. Yeah?
Your Lordship,
All we want
yes.
is this Kenyan.
Your Lordship, the more
Where is he? Nothing more. We are not interested in trouble, we're not interested in anything. There is a human being missing. So where is he? Is he alive or dead? Just that. The responsibility now is on me. They are asked looking upon this court to get this person alive or dead. And we all have a responsibility.
And Your Lordship have confirmed, and I wish to direct that.
You know, I've read the pleadings, Mr.
Yes.
Mao. Let's not go there. I've read the pleadings. Yes. We take your story with the forcefulness it deserves. We take their story. We balance the two.
Correct, Your Lordship.
I didn't watch the video these people wanted me to watch, so I don't know what was said in that press conference. But let me make my few remarks here. not the calendar. Calendar.
Redacted.